The judge in the Kyle Rittenhouse case has snapped several times at the prosecutor as the case seems to be imploding on the prosecution. In fact, it's going so bad that the defense just argued for a motion of a mistrial with prejudice, saying that the prosecutors are doing so bad, they're either trying to get a mistrial, meaning they'll get another chance to prosecute Kyle Rittenhouse because they know they're going to lose, or they're attempting to use unconstitutional means to prejudice the jury against Kyle Rittenhouse. Now, there are two important points in that motion. The judge so far said he'll take it under advisement and then told the prosecutor, I don't believe you are acting in good faith. I've got all of this. We'll go through it. But the gist of it is the prosecutor tried to use Kyle Rittenhouse's right to remain silent against him, actually saying in front of the jury, why haven't you come forward and told your story sooner? Why did you only wait until this trial after you've heard all the testimony to explain your story? He tells the judge, I am trying to basically lay out the case that Rittenhouse is tailoring his version of events based on testimony. And the judge goes off saying, you have just committed a grave constitutional violation. He says you are at the borderline. Maybe you're over it. It better not happen again. And the prosecution tries to make an argument for being allowed to do it. The next thing that happened was that the judge had already ruled certain evidence was not to be admitted. Evidence that occurred 4 months after the night in question in Kenosha. The prosecutor brings it up anyway, and the judge goes off. The defense then says he's trying to get a mistrial. Now, a mistrial with prejudice would mean the case is a mistrial, it's dismissed, and prejudice means that the prosecutor would not be allowed to bring these same charges again. Kyle Rittenhouse would get off on everything. In this heated exchange, and I will stress, at the time of filming this video, the case is still ongoing. In the argument, the judge says, I will take the motion under advisement. Now, I think the judge doesn't want to take away the opportunity of the jury to issue their ruling, but there's already speculation. The judge, based on evidence from the state's own key witnesses, the judge could issue a directed verdict after the jury comes out and issues their findings. If the jury comes out and says not guilty, the judge says, okay, good. If the jury comes out and says guilty, the judge could intervene and say no. Directed verdict on the evidence as a matter of law, not guilty. There are a lot of things that could still come up. And I think this is one of the reasons the judge isn't going to issue any rulings right now on dismissing this with prejudice or issuing a directed verdict. And that's the jury could come back and say manslaughter. They could argue on the gun charges. But Kyle Rittenhouse already has some other victories. The judge recently ruled that the curfew violation charge is dismissed. So this has been nothing but good news for the defense. And it is clear based on the grave constitutional violations of the prosecutor, as stated by the judge, they are desperate here. Now, it gets even crazier. I want to make sure I go through what's happening right now because this is nuts. But yesterday, one of the witnesses who was subpoenaed to testify actually stated the prosecutors brought him in and tried to get him to change his witness statement. This witness was seemingly offended and anxious, saying, you asked me to change my statement after showing me evidence after the fact, naming individuals. This was a shocking bit of testimony, and it was such an egregious violation on the part of the prosecution that they started arguing with the witness, saying, we never did that. That's wrong. I'm watching this legal analysis from Mercado Law and many others, and they're like, why is he doing this? The prosecution looks crazy. It looks like they're trying to plant evidence or something to that effect. Absolutely over-the-top actions. Now, I got to show you a lot of what's going on. The lies from the media have only gotten worse. I want to bring up some of the lies from the past because it really does look like on the merits and as a matter of law, Kyle Rittenhouse is not guilty by reason of self-defense, meaning we know it's a homicide trial. We know people lost their lives, but it seems definitive it was self-defense. There's still the matter of the gun charge. And I definitely want to talk about some of the prosecution's questionings. They were trying to accuse Rittenhouse of trying to act out Call of Duty. No joke. The prosecutor actually argued that hollow point bullets explode inside of animals. It's insane. Rittenhouse repeatedly said, I don't know anything about ammo. I don't know what you're talking about. And the prosecutor's like, hollow points blow up. And the judge intervenes and is like, what are you doing? Let me slow down and let's go through this because this is crazy stuff. Before we get started, head over to timcast.com, become a member to help support our journalists. They're covering tons of stories, especially stories about this case. You'll also get access to exclusive members-only segments from the Timcast IRL podcast, as well as other shows. But don't forget to like this video, share this video. I'm going to show you video clips. I'm going to show you the judge yelling at the prosecutors. And I'll talk about any potential bias too. But I'll tell you this, many people on the left, and I'll show you these tweets, are lying, are absolutely lying. One high-profile Twitter account said, I've not been following this case in minute detail, but Kyle Rittenhouse did travel across state lines with an assault rifle, blah, blah, blah. Never happened. One of the cases being brought forward by the prosecutor is against Dominic Black, who is accused of supplying the weapon in Wisconsin to Kyle Rittenhouse. These people aren't following any of the legitimate trial. They don't know what's going on, and they're putting out lies, and then the media reports it. I got a story from the Washington Post trying to argue the judge is biased, and that's a big problem. I swear, if you watch MSNBC, they're selectively editing this. NPR put out overtly fake news yesterday, claiming that Gage Grosskreutz, one of the people who attacked Kyle Rittenhouse, had his hands up when he was shot. When he testified, he was pointing a gun at Kyle Rittenhouse. Okay, let me slow down. Here. Here's the first story. We got this from Post Millennial. Judge slams prosecutors for trying to use Rittenhouse's right to remain silent against him. Quote, I was astonished when you began your examination by focusing on the defendant's post-arrest silence. That's basic law. It's basic law in this country for 40 years, 50 years, the judge said. After giving his testimony to the judge and jury in his defense. And I also got to add, everyone was shocked that Kyle Rittenhouse was called to the stand. At one point, he breaks down in tears, potentially a panic attack, as he's explaining what happened that night. The judge calls a recess. Here's the news, though. Let's start with the judge admonishing the prosecution. They say Kyle Rittenhouse was examined by the prosecution, who stated their claim that Rittenhouse intended to kill people the night of August 25th. The prosecutor tried to bring up Rittenhouse's invoking his right to remain silent after his arrest, which is a long established in U.S. law to not be permissible. If you plead the fifth and say, I will remain silent, I want a lawyer, you can't, as a court, hold that against him. Juries do. Now, it's risky to have Kyle Rittenhouse testify. Often there is some bias the jury might have saying, why won't he speak up in his defense? But it's because it's a high risk, low reward, and there's a reason for the Fifth Amendment right to remain silent. In this regard, many people are saying it's risky to have Kyle Rittenhouse testify, but Rittenhouse brought up several pieces of evidence that could not have been admitted otherwise. Notably, he stated that Rosenbaum, the guy who chased and attacked him, had threatened his life on 2 occasions. Rittenhouse needed to testify that he was personally threatened, that there was a threat made against his life on more than one occasion. He mentioned that Rosenbaum threatened to cut out his heart. Now, that's something that he would need to testify to, and perhaps that's why they decided it was good to have him testify. However, as noted, I believe this was by Rekieta Law, there are tens of thousands of people who have cried on the stand in remorse and still been convicted. So we'll see how this plays out. Based on how things are going at the prosecution, I think the judge may be ready to say mistrial with prejudice. He took the motion under advisement. We'll see where that leads to. The state tried to show that Rittenhouse was not being entirely honest on the stand, tailoring his testimony after having heard eyewitness testimony and seen media accounts of that night and the reactions to it over the past year. The defense issued an objection stating that the state was trying to comment on my client's right to remain silent. I am making the point that after hearing everything in the case, now he's tailoring his story to what was already been introduced. That is clearly a constitutional violation. Let me pull up some of these clips. This is the wrong one. I'll pull that one up in a second. We have the law of self-defense noting that the defense made a motion for a mistrial with prejudice. Here we have from the Columbia Bugle, judge scolding the prosecution in the Rittenhouse case. The problem is this is a grave constitutional violation. Let me play the clip for you.
You need to account for this.
Your Honor, I don't want a jury here. He's commenting on my client's right to remain silent.
No, Your Honor. I am making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right. You're right on the borderline, and you may be over, but it better stop.
Understood.
So that was one of the moments, but there's more. Take a look at this. Greg Price tweets, "Holy effing ish. The judge just completely snapped at the Kyle Rittenhouse prosecutor." Check this out. He says,
To bring this matter before the jury. I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that.
So this moment when he was yelling at the prosecutor, when the judge ruled certain evidence was inadmissible, it could not be brought up. Notably that Kyle Rittenhouse was wearing a shirt expressing, he said something about being free. He said effing free or something to that effect. The judge said that was 4 months later. It has no bearing on what happened that night. The prosecution tried bringing it up anyway, and the judge goes off. Check this out. Here's another video clip.
I had heard nothing in this trial to change any of my rulings.
So why testimony, Your Honor?
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you.
They made their arguments. The prosecutors then said to the judge that Rittenhouse had given statements to the press in the past, and they wanted to impeach the witness. They wanted to challenge his credibility based on what he had said to the media. I personally, I'm not a lawyer, I'm a layman, but that sounds ridiculous. What did he say to the press? They brought up a quote where he said, "If I didn't have my gun that night, I would have died." How that would now allow questioning his right to remain silent or something that happened 4 months later is an insane argument. The judge actually said, he said, "I don't believe you." The lawyer was like, "I'm acting in good faith." The judge says, "I don't believe you." This resulted in a motion for a mistrial with prejudice. Let me pull this up. Defense threatened. So this is interesting. From lawofselfdefense.com. This is Andrew Branca. Defense threatens to offer motion for mistrial with prejudice. After the second incident, the defense informed the judge that this was an inexcusable conduct from an experienced prosecutor who knows better, that they suspected Binger knew this case was so weak that he didn't want it to go to a jury, that he was angling for a mistrial, and that if he engaged in misconduct again, the defense would offer a motion for a mistrial with prejudice, meaning, if granted, Kyle could never be tried on these charges again. And what did we actually get? We ended up with defense Chirafisi actually making a motion for a mistrial with prejudice. The judge said, "I will take it under advisement." By the time you watch this video, he may actually grant it. Now, as I stated earlier, I personally don't believe that would happen. My opinion is worth very little on this. I'm not a lawyer. I don't have experience with these trials. I have no idea what's going to happen, but I can speak politically. I don't believe the judge wants to have this trial end due to prosecutorial misconduct, because then no one will believe that there was a fair trial. The left will go out and riot. They'll claim the judge was biased. And there are some questions that people are bringing up about bias. But they'll believe that the judge is biased and therefore there was never a fair trial. They will use it as evidence to indict the system again, blame the courts, blame the police, and say they're protecting Kyle Rittenhouse. Mind you, there was recently a mass tragic event at a school where the perpetrator was black and was let out on bail that people are bringing up. I think it's irrelevant to bring up immaterial points in politics and claim, oh, something else happened, therefore this is evidence of that. No. What we need to focus on in this case is the details of this case. I believe at this point, the judge should, is my personal opinion, either issue a directed verdict on the homicide charges, on the first-degree murder charges, or a mistrial with prejudice. The prosecution, as stated by the defense, seems to be trying to get a mistrial because then they get to try him again. Or they're just trying to effectively cheat, to prejudice the jury against the defendant in an unconstitutional way. Now, I got a lot I want to show you on this one. We have a lot of other issues. Law of self-defense tweets, Richards, Binger either forgetting court's rulings or looking to provoke a mistrial. He's experienced attorney. He knows better. If he does it again, I'll be asking for a mistrial with prejudice. Binger says you left the door open on CBS. The judge shouts at him. This is like, there were like 4 or 5 instances where the judge was yelling at the prosecutor saying, for me, not for you. Law of self-defense got it wrong. He said, not for you. He meant the judge said, you can't rule on this. This is where it gets crazy. Early on, Rittenhouse already had some major victories. Check out the story from the Daily Wire. Judge tosses curfew charge after prosecution falls short on evidence. One of the things brought up, I believe this was overruled, was the prosecution said, you broke curfew. The defense objected, saying he's not being charged with a curfew violation. Those charges are dismissed. He brought it up and tried saying you were disregarding the law, trying to prejudice the jury once again on a charge that is not being, that Rittenhouse has already won. The Daily Wire reports the judge overseeing the trial of Kyle Rittenhouse was in Wisconsin last year, blah, 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 dismissed a charge of breaking curfew. Rittenhouse is on trial facing 6 charges, 5 felonies and 1 misdemeanor. The felony charges are intentional homicide, reckless homicide, attempted intentional homicide, and 2 counts of reckless endangerment. The misdemeanor charge is underage possession of a deadly weapon. Judge Bruce Schroeder tossed an additional curfew charge on Tuesday, ruling that prosecutors had failed to produce any evidence that a curfew had been in place, according to CNN. The judge left in place the misdemeanor gun charge against Rittenhouse, overruling the defense's request to have it dismissed. Rittenhouse's attorneys have previously argued that applicable Wisconsin gun law is unconstitutional, according to the Kenosha News. Now, one of the things the defense has argued, I could be getting this one wrong, is that there is a law saying if you're underage, you can't be in possession of a rifle. However, what the defense has argued is that there's a specific exemption saying 16 and 17-year-olds are exempt from this. That is to say, potentially the law was written saying minors can't have this, and then they amended with an exemption saying 16 and 17-year-olds are okay. So if you're 15 and under, you can't. One of the interesting things that came up in the case was that the prosecution on cross-examination of Kyle Rittenhouse asked him why he got an AR-15. They're trying to manipulate the jury in this regard. Let me explain something to you, my friends. Virginia is a good example. If you're under the age of 21 in Virginia, you cannot purchase a handgun. Now, I think that's unconstitutional. It is being challenged. It may have been overturned already. I'm not entirely sure, but I believe that is unconstitutional. A few months ago, I went to a gun store in Virginia. I'm a minute away from Virginia. And what they do is they'll ship it to a gun store in your home state. And then, so you can basically have things sent there. But you can go in the store, look around, say, ooh, that looks nice. Send it to another shop where I can buy it. A young man came in and he said, I'd like to purchase a weapon. They said, how old are you? I think he said he was 20. And they said, you can't buy a handgun. He said, no, I don't want one. I want to get, a rifle. And they said, okay, you can. There are reasons why it is easier to buy a rifle, a long gun. People on the left don't understand this. I believe the prosecution is attempting to manipulate the ignorance of the jury. And I don't mean that in a disrespectful way. I mean that he's betting people in the jury don't understand gun law. Kyle Rittenhouse stated that the reason he did not buy a handgun was because he's not old enough to possess one. In Wisconsin, you have to be at least 18. However, with a shotgun or a long gun, you can be 16 or 17. The prosecutor then began arguing about the law. Then Kyle Rittenhouse said it was his understanding because the police told him it was okay. There was an objection, and the judge said effectively to the jury, it doesn't matter what the prosecutor thinks the law is. It doesn't matter what Kyle Rittenhouse thinks the law is. Ignorance of the law is no excuse for breaking it, and the judge would instruct the jury on the law. But the prosecutor seemed to be trying to make it seem like Rittenhouse was purposefully buying a more deadly weapon. The prosecutor went in to talk about full metal jacket rounds versus hollow point rounds, and this is where things just go off the rails insane. I'm sitting here confused why this line of questioning is even happening. And I think the judge felt the same way. The judge actually intervenes at this point, explaining to the prosecution what they're saying makes no sense. So get this. Full metal jacket. Okay, so you have a softer metal, lead or so, as the bullet. and it's encased in a harder metal, say copper or something to that effect. I don't know the exact composition. I'm not a big gun nut. I don't know a whole lot about it. What I can tell you is the principal reason for a full metal jacket round is that softer metals leave deposits in the guns, and this can cause problems, jamming, misfiring, malfunctions, etc. So this is why people will often clean their weapons. So there are soft tip, meaning it's partially encased in a harder metal, and this reduces depositing. A full metal jacket is completely encased. This reduces depositing. Now, because it's fully encased, a full metal jacket is more likely to over-penetrate. The prosecution was trying to make it seem like Kyle Rittenhouse was reckless by using a standard full metal jacket round. It's a basic round, okay? The prosecution asked him about hollow point rounds and actually says in front of the court and the jury, hollow point rounds explode inside of their target. Rittenhouse was like, I don't think that's correct. That's not true. And the judge intervenes and says, do you mean expand? And the prosecution is confused. The judge actually had to stop him saying, what you're saying is factually wrong. It makes no sense. I got people tweeting at me saying, actually, full metal jackets are designed to overpenetrate. They were trying to argue that because, and full metal jacket, as you need to understand, it's basic. It's like a basic, standard, commonly used round. They're not designed to overpenetrate, but they are more likely than hollow points. Hollow points flatten in their targets. They expand. Now, if you want to talk about overpenetration, meaning a weapon, a bullet that is designed to go through the target, you're talking steel core. There's armor piercing. They can go through metal. A standard full metal jacket, say Rittenhouse was using 223, is not necessarily designed for that purpose and not guaranteed to overpenetrate. The judge actually has to intervene. All right. There's a lot going on. Let me actually address some of the charges of bias. In this tweet, we have from David Carlson, the judge's ringtone is proud to be an American. It is literally so over. Now, if you are, I don't know if this guy is on the left or right. He's a social media manager contributor to Populist Union, so probably something more on the right. But I will explain to you, this is actually bad politically for the judge. Let me play this clip.
The actions that I had talked about.
As you can hear, the judge's cell phone rings, and the song playing is Proud to be an American. The judge has already been accused of bias, and I believe incorrectly, because the judge actually is not giving the defense everything they want. The defense wanted the reckless endangerment charge dropped. They wanted the gun charge dropped, and the judge is saying, no, the jury can decide. I think he's actually being quite fair. But this argument here being presented is more ammo for the left to say, proud to be an American? While he's certainly a conservative, I believe that's a ridiculous argument to make. But let's be real here. The mainstream left, the establishment left, would not play a song like that. That is not something that they would entertain or promote. And I think it's fair to say the judge is more likely to be moderate or conservative leaning, in which case the perspective on this case may be more moderate or conservative leaning. Not that he's biased in favor of Rittenhouse as an individual, but that the law does support Rittenhouse's claim of self-defense, that the state's own witnesses have, and if the judge is going to be fair and treat this fairly, it's good news for Rittenhouse. As we can see with the claims made against the prosecution, the actions they've taken, and how the media has lied and manipulated, how social media has censored information, we know the establishment left and many leftists are not being fair on this one. That is to say, if the judge is more likely to be conservative, he'll be fair, even if it means bad news for Kyle Rittenhouse. Ultimately, I think it will be somewhat good news. Now, one of the big moments today was Kyle Rittenhouse breaking down, sobbing on the witness stand. I don't know if he was actually crying. You can see some, moisture in his eyes. He's hyperventilating. I would say sobbing is the appropriate word. He's getting to the point in the story as he's testifying about what happened that night. A recess was called because he begins hyperventilating and struggling to speak. I would say it was like a combination of a panic attack and sobbing. I don't know if this was the right move. As I mentioned with Rekieta Law, he stated, I believe it was him who said this, that there are tens of thousands of defendants who have cried on the stand in remorse and have still been convicted. I've also heard from many people saying that the moment they saw him crying, they felt that he was being traumatized. It was malicious prosecution. All the evidence we've seen so far indicates a self-defense. The prosecution has committed grave constitutional violations by the judge's own statement. They've gone after his right to remain silent. They've tried admitting inadmissible evidence. And their own witnesses have basically supported the claim of self-defense on more than one occasion. And I've got prosecutorial misconduct for you right here. Take a look at this. Defense witness Nathan DeBruin, amateur photographer. Check this out. Andrew Branca goes on to mention, this was yesterday, that DeBruin seemed an unlikely candidate to be the defense's most powerful witness on the day because he presented and conceded that he was extremely anxious. Despite this, DeBruin was absolutely coherent and firm in his testimony, almost driving ADA Krause into a rage with his calm and cool testimony. At times, ADA Krause's cross-examination of DeBruin became completely unprofessional and almost personally bullying. No joke. I watched this live. I was shocked. Perhaps nothing was as damaging to the prosecution and as personally infuriating to ADA Krause as DeBruin's testimony that in a meeting with ADA Binger and ADA Krause, he had the perception they were asking him to change his statement to police about what he had observed on the night of the 25th. Here, change should be read to mean falsify, in particular, to falsify some conduct or presence of Joshua Ziminski. On the stand, DeBruin testified that he made a statement to the police. That was it. Later was called in for a meeting because he was threatened with a subpoena, shown video evidence, told by the prosecutor that's Joshua Ziminski. And then when DeBruin said, oh, okay, the prosecutor said, would you like to now change your statement? Which is to say, the statement he gave on the night in question was the true witness testimony that he had. After the fact, seeing other evidence or videos may change his understanding. In this instance, the prosecutor, according to his testimony, wanted him to add commentary to his statement to help the prosecutor prosecute Ziminski. That is gross prosecutorial misconduct, and DeBruin would not back down. Because of those claims, the prosecutor, Krause, went up there and started yelling at him for a long time, no less. DeBruin basically saying, you wanted me to change my statement. And they're like, no, we didn't. It was amazing when Krause said, we never asked you to change your testimony. And DeBruin goes, yes, you did. You showed me new evidence and then said, do I want to change my statement now? He felt that was them trying. He was really uneasy because it's basically like the state saying, you saw this, didn't you? You don't want to get subpoenaed, do you? And then the ADA was like, you came in because you were threatened with subpoena. And he goes, you did subpoena me. I'm looking at this and I'm like, the prosecutors are just acting with impunity. These are evil people. Interestingly, let me see if I can pull up this, find this tweet from Mike Cernovich. Mike Cernovich mentions, I think, let's see, where do I have it? He says, if this case is dismissed due to prosecutorial misconduct, double jeopardy would apply and Rittenhouse could not be retried. The prosecutor isn't trying to get a mistrial. He's willfully evil. He got away with it in other cases and couldn't adapt to having a real judge. That is to comment on when the defense, I believe Cernovich made this statement before the defense made their motion for, he did say this before the motion for a mistrial with prejudice. The defense was at first saying either he's trying to get a mistrial or he's trying to prejudice the jury. Cernovich's point is that they're trying to prejudice the jury. They were hoping to get away with it because they've done it to other witnesses. Now let's talk about where we're currently at in terms of the past. We have this story. Utah paramedic uses government email to donate to Rittenhouse Defense Fund. The media went after people who were helping Kyle Rittenhouse's legal defense. Some of these people lost their jobs. This was doxing. It was political. Facebook was banning people. To this day, Twitter is still banning people. It's a dangerous line. The evidence we have seen, the prosecutorial misconduct we have seen, supports Kyle Rittenhouse's defense. The state's own witnesses support Kyle Rittenhouse's claim of self-defense. And still, the media, big tech, are doing everything in their power, seemingly, to destroy this kid's life, this young man's life, and anybody who would dare support him. People are getting suspended on social media. Look at what they claimed last year. Huffington Post, white supremacists were on a hunting spree in Kenosha, says Wisconsin lawmaker. Absolute lies. Look at this from the Washington Post. As Kyle Rittenhouse trial nears end, judges' decisions from the bench come under scrutiny. Because establishment Democrat players, the media, leftists are not acting in good faith. I'm watching CNN's Jeffrey Toobin. And he's like, Kyle Rittenhouse is a stupid idiot, a moron, and blah, blah, blah. To be fair, though, he did say he does have a plausible self-defense claim. I can respect that. But the judge actually slammed Toobin on CNN. This is the guy who previously lost his job for inappropriate behavior in a Zoom call in front of his coworkers, but I digress. The judge was like, why am I being criticized by the media when I'm following the law to the letter? This is how insane things are. Take a look at this. Southpaw tweeted, and this is a guy, Southpaw is a lawyer with 241,000 followers. He said, I haven't followed the Rittenhouse trial in minute detail, but I believe it remains the case that he traveled across state lines with an assault rifle to oppose a protest in a community where he did not live and ended up shooting a bunch of people there and killing 2 of them. This is somebody who is fanning the flames of chaos and destruction in this country, and this is an example of the problem. Southpaw has not been watching the trial. As I mentioned already, one of the cases being brought forward by the prosecutor is against Dominic Black for giving a gun to Kyle Rittenhouse. That would mean that the narrative of crossing state lines with an assault rifle isn't true. Furthermore, I know it may be semantic in a sense, but we need to make sure we're getting definitions clear. Not a single person in Kenosha was armed with an assault rifle, period. Assault rifle, by most the most standard colloquial definition, is a select fire rifle. Those are, for the most part, not legal to possess. They're NFA items. You can get them, but typically most people do not get them because they cost upwards of, $10,000 to $30,000. Typically, they're manufactured before, I think, 1984. But again, I'm not trying to get into the nitty-gritty details on gun issues and laws. The point is, if you want to argue he had a long gun, a rifle, fine. Let's just say Southpaw intended to say long gun, rifle. He did not travel across state lines with it. And that is all we hear from people who don't pay attention. People who want this kid to go to prison for the rest of his life for charges that are wrong, for now a prosecution that is clearly malicious, clearly engaged in misconduct, prosecutorial misconduct. These people want this kid to go to prison, not for any matter of justice. And let me tell you, shout out to Anna Kasparian. She says I was wrong. She admits she bought into the false Rittenhouse narrative. She thought Rittenhouse chased after Rosenbaum. She says, I was wrong about that. I want to correct the record. These details matter because if you're going to make an argument that you acted in self-defense, there needs to be some proof there was an imminent threat. What really mattered to me is how this all unfolded. What was the thing that sparked it, etc. Good on them for admitting that they were wrong, or Anna Kasparian admitting her wrong. I mean that with absolute respect. This is the right thing to do. And I think when these people actually recognize the evidence shows that they were wrong, they should acknowledge it. Anna did that, and she has my respect for doing so. That's it. I won't comment anymore on her positions. I will say the problem we face right now with Rittenhouse is that you've got a prosecutor clearly engaging in misconduct. And because these people don't care to look at the evidence, they don't care to go through the video, they don't care to watch the trial, they spout this nonsense and rally violent extremists to the street, threatening riots. If all of the people acted the way Anna Kasparian did, we might actually walk away from this one without chaos and destruction. But they don't. So I'll leave it there. It's still ongoing. By the time you watch this, who knows what will have happened? For all I know, I got to record another video because a mistrial was declared. But we're going to talk about this tonight over at youtube.com/TimCastIRL, 8 p.m. Check it out. We're going to have all the updates. This may be the last witness. So we may be very close to a verdict. I'll leave it there. Thanks for hanging out, and I'll see y'all at 8 p.m.